Good morning, everyone. Welcome to the Committee on Professional Responsibility and Conduct. This meeting is being recorded. Angela, would you please take roll?
Yes, taking roll. Sarah Bonola. Elizabeth Bradley. Present. Raquel Brown. Present. Cassidy Shivers.
Here. Here. Can you hear me? It's very low, but I can barely hear anybody.
Oh, okay. Joel Mark.
Here.
Eleanor Mercado.
Here.
William Munoz. Daniel O'Reilly.
Here.
Vikita Poindexter.
Here.
Avi.
Here.
And Hunter Starr. Thank you.
So next on the agenda is a call for public comment. Angela, do we have anyone?
For those participating by Zoom, you have a raise hand function on your screen. If you would like to give a public comment, please use the raise hand function at this time. We will allow 3 minutes for each speaker, and the on-screen timer will begin, and you will be verbally alerted at 30 seconds. At this time, is there anybody who would like to give a public comment? Please use the raise hand function. No public comments.
I'll make a public comment just to let our remote attendees know that they are missing out on some spacious accommodations, and we really miss you all. So why don't we start with the approval of the minutes from the last meeting? May I have a motion to approve? All right. Anyone want to second that motion?
I'll second it.
Okay, I'll take the vote to approve the minutes from the last meeting.
Sorry, just, that was a motion by Bradley, second by Mercado, is that right?
Yes.
Thank you.
Brown,
Angela, it's very hard to hear you guys.
is it? All right. Is that better?
No.
Is anybody else having trouble hearing?
Yeah, I am. We all are.
Everyone.
as
Okay.
well.
Can you guys hear me, Erica?
Yeah, that's better.
Okay.
Yeah.
You put it really
Much,
close.
much closer.
All right,
Turn
I
your
will
console.
just be closer. How's that? Better?
Better, but not great.
Okay. Well, let's try to do this vote, and then hopefully we can resolve the issue. Okay, so this is the vote to approve the minutes from the last meeting. Brown?
Yes.
Bradley?
Yes.
Shivers?
Yes.
Desmond?
Yes.
Mark?
Yes.
Mercado?
Yes.
Munoz? O'Reilly?
Yes.
Poindexter?
Yes.
Ravi?
Yes.
Starr? And Krieger?
Yes.
10 yeses, so the motion passes.
Great. My chair report is brief. I would like to thank everyone for all their great work, all the members and staff for all the work on the symposium. I understand we are collecting feedback from the public, and we'll have that for our next meeting so we can continue to craft and improve the symposium experience going forward. So I will turn it over to Erica for a staff report, if there is one.
Yeah, I'll be brief, thank you. So we will be sending the evaluation surveys from the symposium to the moderators. So for those of you who were moderators, you can expect to see that in the next probably a couple weeks or so. And then, as Brandon mentioned, we can, if the moderators would like and if the committee would like, we could certainly discuss that at the upcoming June meeting. The only other things to update is that, as we had talked about a couple months ago, the COPRAC will be undergoing the sub-entity review process through the Board of Trustees. That has been somewhat delayed, so that has not started yet. So in case you're wondering what's happening, it's just hasn't started. But you will likely be hearing when it does. And then the only other thing I wanted to mention is that COPRAC is in the process of interviewing new applicants for the committee because there are a few people who will be terming off at around the October meeting. So the COPRAC's officers, so Sarah as advisor and Cassidy as vice chair and Brandon as chair, are currently interviewing new applicants for COPRAC, and those will go to the Board of Trustees for approval at the Board of Trustees July meeting.
Thank you. So our first agenda item for substantive discussion is B1, ethics of in-house counsel. And what we would like to talk about is extending the public comment deadline. I think there are some ethics committees that didn't quite get their comment letters together in time. And I think these, especially the ethics committees, but all public comment, that's really, really beneficial to the work we do. I don't think we should be digging into substantive revisions without gathering all the intelligent feedback we can. So what I wanted to discuss was extending the public comment period by 30 days. Does anyone have any thoughts for or against that?
I think that's fine. I've done a quick review of what we do have. Well, we're gonna extend the public comment period for 30 days and then we'll have a substantive discussion at the next meeting.
I think that's
I'm
right.
wondering if we can have the subcommittee just in between then do a review of the existing comments that we do have. So that I can have some input from the people on the subcommittee on those comments that we do have. And then we can address the new comments as well at the next meeting.
That sounds like a great idea. So we would vote to extend the deadline by 30 days, and then the working group would still get together and talk about what we've received and what we think of it.
Yeah,
Staff can continue to forward, if we do receive additional public comment in the 30-day extension, we can just forward those on to the subcommittee as they come in, if that works. I think that if it was extended for 30 days, it would actually put the substantive discussion of that opinion probably no sooner than the July meeting, just realistically, which would be just fine, but just to make you all
Yeah.
aware, it's probably not realistic for it to happen in June. Given the
no,
time.
I know, that's true, and I agree.
Okay. Well, can I move that we extend by 30 days? Is that fine for the chair to move? I don't remember. It's been a long time.
I think it's not prohibited, so.
Okay, great. I move. Does anyone second?
I'll second.
All right,
Second it.
thanks.
Okay, so I have Brandon moving and Elizabeth seconding for a 30-day extension of 19,004. I'll take the vote. Brown,
Yes.
Bradley? Yes. Shivers,
Yes,
Desmond,
Yes.
Mark,
Yes.
Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter,
Excuse me, yes.
Ravi,
yes.
Starr, and Krieger.
Yes.
Okay, so it's unanimous. 10 yeses, the motion carries.
Great. Well, we're making great progress today. So the next item on the agenda is E1, the client file release and retention duties. And we have included in your materials the second round of public comments on this draft.
Brandon, sorry, do you want to talk about public comment on everything else real quick, just a high level?
Would you be so kind?
Yes, I'm happy to.
Because I wasn't about to. Thank you.
Sorry, so there are currently, after the in-house counsel opinion 20-0003, there's another item that the public comment period ended on April 30th. That is the arbitration advisory 2022-OXA. And those public comments have been forwarded to that working group, which Joel, I think you're the lead drafter on, if I recall. So there were nine comments received, and two in support, 3 suggested some modifications, and so those have been provided to the working group. And I'm assuming that the substantive discussion of those comments will be at an upcoming meeting, either in June or July, as well as possible revisions to the opinion.
Right.
Yeah, I've received them all. I've considered them all, and they'll be back on the agenda for June for sure. I got to tell you though, it was the first time, it was an absolute first in 19 years on the Mandatory Fee Arbitration Committee and now 4 years on COPRAC that I saw a public comment having to do with how small claims matters are handled on the Judge Judy show.
Fantastic.
But I considered all of them, and basically they are two of them were typographical kind of errors, which can be corrected, and the third one, the substantive, the lengthy one, was a long way of saying that we weren't clear on whether the prior advisory was superseded or modified or remains in existence or whatever. So all those things should be able to be corrected when I can get to it next week, and I'll have it back on the agenda by June.
Erica or Angela, can you tell us who the members are on that working group? I just want to make sure it's on my radar.
I think it was Ken and I,
Right.
and with Ken's departure, I just finished it up.
I don't know if we can call Joel a group.
I think there are a few more that were added last time. So
So
that
I missed that. So if
it's
somebody,
Joel, Brandon, Elizabeth, and Sarah.
oh, okay.
So I don't think I got the public comments, or maybe I just missed them. I did. All right. So I've just confessed, but I will look at them. I will find them, and I will be ready to talk about them on our working group. Yes.
I am happy to resend those.
Well, that would be delightful.
Great. And then there's three, very just quickly, there's three opinions that are still out for public comment, with the public comment period for those opinions ending on June 7th. That is the succession planning opinion, which is out for a second round of public comment. So far, we've received 7 public comments from 6 individuals. Of those who provide actual comments as opposed to just indicating support or opposition, most of the feedback so far is that there will be difficulty in finding a successor attorney, assuming that they have done the initial analysis and determined that they need to have a succession plan in place, and that the opinion should clarify how to assess whether there should be a succession plan in place, and then if there is a need, what that succession plan should look like. I think this is actually pretty consistent with what was discussed before it went out for public comment, with once the opinion, assuming the opinion is adopted, that COPRAC could maybe provide some additional guidance in the form of not an opinion as to kind of best practices or a bit of a roadmap for people that may need to develop a succession plan. In regards to the flat fees and termination opinion, there's 3 comments, but none of them have provided actual comments themselves. They've just 2 indicated support and 1 in opposition. And then the final, which was an update to the colleague impairment opinion, which is current opinion 2021-206. If you'll recall, there were minor modifications to address new rule 8.3 to describe that there could be an obligation as it relates to addressing your colleague's impairment to also report them pursuant to 8.3, as well as just some clarifications of what the lawyer assistance program offers. There are 5 comments, but none of them address the changes that were proposed. All of them are going back to concerns about the underlying basis of the colleague impairment opinion. So those can certainly be addressed once the opinion is, once all of the public comments are received, but nothing related to the changes.
Is there still a working group for the colleague impairment, or is that like too old? And I'm just wondering who's going to look at these public comments on the committee.
I think it's to be determined. So when this was updated, it was done by staff.
Okay.
I think you looked at it.
Right.
But it was done by staff. So at that time, yes, if there is consideration that a working group needs to be developed to incorporate changes, that will have to happen probably at the next meeting, because we'll have all of the comments by the June meeting.
Okay.
Erica, could you also tell me who's also on the 200003 flat fee with me?
Yes, Angela and I can race to see who can get it to you first.
I think
One
I
second.
was, Joel, right? Wasn't I on that for a while?
I believe we were, but I kind of, again, lost track. I know Ken was, and like I said, he's gone, so. Who do I include and gather up, let's get these together?
Give me 1 second, Joel, and I will get that.
You could just email it to me later, that's okay.
Okay.
All right. So let's talk about 19-0004, client file release and retention duties. So I believe Hunter was the initial impetus and lead drafter for this opinion. Other people have been doing work on it in his absence, but I don't know that anyone here today has criminal law experience, which does relate to some significant parts of this draft. So I just want to throw that out there because I think it's important. We received a lot of public comments on this client file draft. I would generalize to say that most of the sole or small firm practitioners voiced significant concerns about the expense of retaining criminal files for the life of the client. Some voiced concern about what they viewed as the impracticality of knowing or figuring out whether the clients are still alive. Then there were comments from some institutional defense-related organizations talking about how important and useful this rule is, especially for criminal appellate work and habeas corpus work where prior criminal acts are being considered in penalty phases for subsequent cases, and that it was really vital that this evidence in client files be retained. So all of the public comments have been included in the materials that all the members received for this meeting. I'd like to open it up to see if anyone found anything particularly persuasive or concerning that they want to address in the draft. And then if we talk about that a bit, I have some thoughts about the draft as well. But does anyone have any comments on this draft? We're going to make quick work of this meeting today. You guys can make something up here. Okay. My concerns with the draft are that, consistent with a lot of the public comments, there were people seeing a lack of clarity as to whether we are suggesting that even for misdemeanor matters, that those client files need to be retained by the attorney for the lifetime of the client. I don't think that was our intent. I do think we could clarify that. We are talking about felony matters, felony convictions, and retaining that for the life of the client as ascertainable. I am sympathetic to the challenges of figuring out for certain practitioners whether their clients are still alive. But I do think there's sort of a reasonableness implied in this opinion. We could underline that further, that you're using, diligent efforts to try to figure this out. And I would suggest a clarification that we are not talking about misdemeanor matters, that we are talking about felony client files. Does anyone have any thoughts on that?
Brandon?
Yes.
When we were preparing for our symposium presentation with solo and small firms, we were commenting and sharing with almost everybody, including me anyway, has their entire practice residing on the computer I'm speaking through right now in electronic form. Does the opinion discuss the advisability and the appropriateness of, or whether it complies with reducing everything to an electronic version of storage?
It does. It does. It talks about, actual physical items. It talks about inherent, where originals are necessary. And then it talks about electronic files being satisfactory to meet this obligation. One of the things that the public comments, and I would infer that a lot of these commenters have practices going way, way back in time, right? Before things were routinely scanned as they came in. And they talk about having mountains of paper files, maybe in their garage, and the cost of scanning being enormous, and that's a huge burden to put on these people that are, you know, in many senses, dedicating themselves to this like public service function. It's not a, you know, for a lot of these representations, it's not a high-paying endeavor, and then they're getting hit with this, in their view, additional lifetime expense. I do think that going forward from today, it's not objectionable. Almost everything in most law practices is electronic, and for most items in the client file, the electronic scan is sufficient, right? Some of the commenters talked about that there should be some fund. There should be some, you know, the government should either take on this responsibility or there should be some fund for this because, you know, there's people trying to retire from their practice. They don't have income coming in and they have this, what they view as a very expensive obligation. And I'm sympathetic to that, but I don't think it changes the ethical duty, right? I do think, unfortunately, we're not the committee that can create a fund, but I wonder if we could recommend something like that be created. But yes, to your point, the opinion does talk about electronic scans, and that will, for most items in a client file, or for maybe all items in many client files, be satisfactory and much less expensive. And
does it also discuss, and I apologize for not at the other, but recently, does it also include the advice or urging or best practices comment about the advisability of tending to all those old files as you go along? My horror story arose out of my firm in Ventura had to close its doors 12 years ago. You know, the three of us who were left holding the bag were faced with client files, fiscal client files in storage going back as far as 1939. The firm had never cleaned up all these files, and it was an absolute nightmare. And I would, this is the best practice.
that's a great idea. I don't think the firm, I mean, that the draft talks about, you know, being proactive in that sense. It's a great idea, and I don't think it hurts to mention it as a best practice, that you should do this routinely. Dan, sorry, I'm just noticing that I can see the hand symbols.
Oh yeah, I had a comment about the challenges we might have with the misdemeanor felony distinction. In part, I think it's a practical attempt and it's a good point to make the expense of the obligation somehow related to the seriousness or the significance of the matter. But I don't see a rationale for limiting it based on misdemeanors when your liberty interest would still be at risk, which I think is the reason why the criminal things are so important to retain.
That's a great point, and I think I was a bit inarticulate. The idea that I was thinking was, you know, you have this obligation for felony matters. For misdemeanors, you have an obligation to assess. I don't know if that is just punting and not really dealing with the question. And again, unless I am misremembering, nobody talking here today does criminal law. So I'm trying to figure out how to proceed. It's a challenge. I don't know if we table this for a while until we have somebody who can illuminate this. Because I think we can all conceptually agree that for things that are important to implicating liberty interests now or down the road when could be other charges, that's different. But I don't know how to describe that because I don't practice in that area of law at all.
Right. I think it'd be important to have somebody who does know that practice. I agree with that. It gets tricky because everybody is going to want to expand the whole opinion to be, let me just assess, right?
Exactly, right? And then it's of limited value.
Right.
Raquel.
So is Hunter no longer with the committee, or what's the
He's just
status?
been unavailable. But doesn't his term
Is he
end?
ending his term also?
do we know when?
Yeah, so his term ends effective around the October meeting, so he only has a few meetings left regardless.
Mhm.
So, but I believe he's the only one with criminal experience, and he's also the only one, I believe, left on this opinion. So this opinion has gone through, it's from 19, so it's 5 years old, or around 5 years old.
We start school shortly.
Yes, and it has gone through 2 rounds of public comment already, which may be worth considering for, just, there was an impetus for this opinion, which was the changes to the rules of professional conduct and the discovery requirements that are cited in that penal code statute. So that's where this came from. It was based on a statutory request for the state bar to consider all of this. And it's, certainly stalled, which is why it's before the committee today. So I think some guidance as to how to move this forward would be very helpful. I think I certainly agree with Brandon and Dan saying that no one, we should perhaps consult with, maybe the public defenders associations or, prosecutorial associations. And we could do that. We could send it, just because there's no one on this committee that has that background, that doesn't mean we couldn't, the working group, assuming that there is a working group, couldn't ask for someone to take a look at this and say, hey, does this really make sense? And obviously if it went out for public comment again, it could be done in that fashion, but I don't think there's anything that would preclude the committee from doing that
Can we just,
in advance of sending it out for public comment.
can we just reach out? So, the AI working group, we had these wonderful people bringing their perspective and expertise to us. Do we have to do that in some formal structure, or can we just reach out? Can we have a working group for this? There's nobody on the working group right now, right?
Currently,
This
yes.
opinion is an
there's
orphan.
there's no working group.
We need to adopt this
Yeah.
opinion and then reach out to some criminal practitioners and report back? Is that okay?
Yeah,
I'm with the Bagley Clean and all the.
so they're not members of the committee, so there's no Bagley Keene issues, and any action on the opinion would be at a properly noticed meeting.
Okay.
That's kind of a new way of CoPrac. AI was
Yeah.
the first time where that
Yeah.
had really been done. But these opinions touch on so many different practice areas. It
Right.
does seem to make sense that we wouldn't just be relying on the knowledge that exists in the committee
Yeah,
for,
that's a
for areas
terrifying thought.
that,
Yes.
that they may not be necessarily that knowledgeable about. So that's certainly something that could be done.
So I would propose, well, okay,
Mary Grace.
oh, sorry. Mary Grace? Yes.
Would we want to get a sense from, say, because when I was in law school, I worked for the Innocence Project. Would we want their input in terms of that type of, for lack of better words, temperature as to, how if we were to destroy like a misdemeanor, and given the fact that we have people who might be subject to 3 strikes, and there may be a factual claim of innocence or whatever, and the destruction of documents can impact them. Is that I don't mean to open up a whole bag of worms, but would we want to seek their input and get a sense of their thoughts on this issue?
I think that's a great idea. And then it's funny because these, I think most of the public commenters do criminal defense, right? But there's sort of institutional defenders that really want an expansive obligation. Then there's the sole practitioners who are saying this is burdensome and ridiculous. And I think we should reach out to all of them and try to figure out whether we can come up with some sort of test that we can put in the opinion as to, what sorts of things must be kept for the life of the client and what is not subject to that requirement. But I think reaching out to the Innocence Project is a great idea. So let's do this. I will volunteer to be on this working group for the remaining months that I'm here next year. I just can't vote, which is a thrill. But who also wants to join me in adopting this opinion and reaching out to criminal practitioners? I know it's exciting. Somebody's got to join.
I can assist since I have connections with, I haven't been involved with them in a while, but I could definitely help with the Innocence Project and connect with them. Since it's my, I went to Santa Clara, so I can reach out to them.
All right. Okay, thank you, Elizabeth. All right, so
I'm thinking maybe there's sections at CLA, the CLA Ethics Committee, I'm sure looked at this, but they want to reach out to.
Great. Let's do it.
Brendan, I want to join that committee as well.
Yes, great.
And Brandon, I'm also happy to join.
This is a well cared for opinion now. This is great. Thank you. All right. Pika. 1, 2, 3, 4, 5. So we've got like 5 people now. Great. Yeah, all right. So we don't need to vote on any of this, right? We just do this do we need to vote to do anything?
No, there's no vote. Yeah.
Awesome. All right, we're just gonna do this. The other thought I had been talking about a little bit with Erica was, and we can talk about this in our new working group. Is our working group too big? 5's good? Okay. Is getting rid of the hypos because they don't really illuminate a lot, and we always get the please make your opinions shorter. And if our hypos aren't vital, maybe we make it shorter. But we can talk about that on the working group. So,
You're the chair, Brendan?
I guess so.
Okay.
Yeah, I'll be the leader of the working
Yeah, the
group.
lead. Okay, thanks.
Okay. So, do we need to take a break or anything? No, we're good. All right. I would like to move on to lawyer as an expert witness. So, and just as an overview, Sarah's going to talk about the first 2 examples, scenarios, right, in this opinion. And then I want to talk, she did red line changes based upon the public comments that I think are perfect, but we'll see what everyone says. Scenario 3, I want to talk about and open it up to the whole committee because I have discomfort with the conclusion reached in the draft, and I want to see what other people think as well. So, but now I will turn it over to Sarah.
All right. I realized that in preparing for this meeting, I think we were mistaken in that we already went over these red lines to this draft opinion at one of our prior meetings, which were made in response to public comments. So I'm not going to go one by one through the red lines, which I think we already discussed at the last meeting, unless anyone has any questions if you reviewed it ahead of the meeting. And we also already discussed this first issue. And I think the plan was to go back to the working group and discuss this. And unfortunately, I think we overlooked that. But when I review this again, I realize we've already gone over this. But I do want to raise the number 2 on the screen again for discussion purposes. I think it's important, which is, you know, and I'm sorry, I'm having trouble seeing right now because I have this sun shining bright through my window that I'm not able to. I'll try to turn. But my basically it's just scenario 3 where it's a concurrent testifying expert and law firm representation in unrelated matters. And right now, the opinion concludes that would be permissible given the facts of that scenario. However, a couple of the public comments and even COPRAC's working group and this full committee had some concerns about that type of situation. One from a business practice, which obviously I don't think we should get into in the ethics opinion, you know, that a lot of us probably would not undertake that type of representation. However, there is concern from a duty of loyalty perspective to your current client, whether this would be prohibited. And we wanted to explore that more. And I think Brandon was going to take that on more. But first, we wanted to discuss it among the group. I know we've talked about this scenario 3 in the past, just what others feel about this. I think that the hardest thing here is that there's nothing really clearly in the rules or the case law that directly addresses the situation or would say that it's prohibited. There are some federal cases, and one of which we've cited, that indicate that it would be permissible. And then we've talked about this Oasis case before, but that really involves a different factual situation. And that was based a lot on the similarity between the 2 matters, where here we're talking about completely unrelated matters. So I'll pause, see if Brandon has anything further to add, and then open it up for some discussion.
Yeah, the only thing I would add is I think the analysis in the draft that we have, analyzing, you know, if you start from the proposition that we have taken throughout the whole opinion, that expert witness work is not the practice of law, right? and then you analyze the RPC, I think the analysis is correct, that it's not a violation necessarily of 1.7, but my sort of intuition is deeply concerned and offended, and I just want to probe that. I think the lawyer's duty of loyalty perhaps goes beyond that, the prohibitions articulated in 1.7, and I can't imagine any client being comfortable or not feeling that there was disloyalty afoot when lawyers from that client's law firm are acting as expert witnesses contrary to that client. I would never do this, and I've heard almost everyone on the committee say they would never do this. And I think I want to just probe that further, because I'm not sure what the analysis is, but I would never do this, and I think it's wrong. But if people think otherwise, then I'm not the right person to tweak scenario 3, because I'm not really on board. But I just wanted to test the feelings of the committee as to whether it would be permissible to be an attorney at a firm representing a client, but in a separate matter, act as an expert witness against your firm's current client. Somebody's got some thoughts. I know.
I'll throw my 2 cents in. It's something that we're on the same page, Brandon. I feel like I've said this before, but to me, this scenario doesn't make sense, and I think it would be a duty of loyalty resolution. I don't think you can. And I mean, working from a different angle was, I think I've said before, if there's something in this opinion that we're saying is permissible, but none of us would do it, what is the rationale for including it?
Yeah. And do we think it
can't be right?
And that, perhaps we need to do research on beyond the RPC, just into attorney's duty of loyalty, and see if there's a hook that is the source of our discomfort. Joel? Can't hear you, Joel.
Sorry, yeah.
All right.
And they might even be, I'm thinking of the 2 COPRAC opinions which talk about when a lawyer does things that are not the practice of law.
Joel, can I ask you to speak closer to your microphone or something? We're all having a little trouble hearing here.
Yeah, I'll try and do that. There are 2 COPRAC opinions. I think it's 141 and 154. I could be wrong, which talk about the duties that a lawyer has, even when they're doing things that are not technically the practice of law. And they both speak about what duties they have to the same client, so they're not directly on point, but and they might even be mentioned in the draft we have here, if for nothing else, and to explain that the expert witness is not the practice of law, but they may provide some guidance in this area, because the conclusion, I think, in both of them is that although the specific activity is not technically the practice of law, the lawyer, at least to the client, that they're also practicing law for, retains all of the duties that a lawyer has to the client. And I suspect that when you're talking about testifying adverse to a law firm client, that may indeed be an applicable situation.
Eleanor?
Can you hear me? Yeah, okay, thanks. I wonder if the duty, I mean, I see the reference to the duty to communicate in the rule, but it doesn't look like it's mandatory. I mean, am I reading that incorrectly? It does say should, but it doesn't say must. I don't know if, I can't remember if we use should as must in some of the opinions, but it seems to me like that rises to the level of important enough that you must disclose it to a client. I mean,
Yeah, we conclude.
I can
that
see the
disclosure is not
rationale for,
necessary. Sorry, we conclude that disclosure is not necessary, which doesn't sound right to me either.
that's the part I'm more concerned about. I mean, I can see it not being a conflict under the rules, the way I read the rules, but I don't know. I mean, it seems like an important development. Maybe it's not related to the case, but an important enough development that you would have to disclose it.
Interesting.
Maybe a little bit of research into the communication
Yeah, well,
as well. I could be reading that more broadly than it's intended, but
no, I think that's really important. Should we do like a little straw poll? I mean, and see who is comfortable with scenario 3 as written in the current draft? If anyone loves it, and because then I want to hear from them and consider it. We'll just try it that way. Does anyone like section 3, scenario 3 as written? All right. So what I think we need to do is dig into these, these COPRAC opinions, the 1.4 issue, and sort of report back and see where we go with this. Who's on the working group? I keep asking the same question every time. I apologize. Who's the working group for this draft? It's me and
I think I might be on it because I was talking so much about it. If not, I'll join it.
all right.
I felt shamed into it.
Love it. Joel, are you on our working group still? Do you want to be? Oh, I can't hear you, Joel.
Yeah, I think I was once, but
All right.
okay.
So,
I did it
all right.
wrong. Yeah.
So I think what we'll do here is have a working group meeting and talk about sources of our discomfort and see if this is truly prohibited or just something we don't want to be seen as encouraging and to differentiate between duty of loyalty and the 1.4 issue, which I think is just wrong. I can't imagine finding out later when you're at the deposition that your attorney's partner is testifying against you in some other case. I wouldn't enjoy it. So.
that just seems like an undermining the confidence in the profession type of issue and other types of, I mean, it feels like there's got to be a duty to communicate it.
Yeah, I'm curious now to go through the duty of loyalty because I feel like there's got to be something there along the lines of what Joel discussed, where it's got to be broad enough to cover something like this.
And following up on what Eleanor said, I know we talked about the duty of communication previously and analyzed it under, A and B. And looking at it again after some passage of time, I it's hard under A, I think, because everything's related to the representation. But I think under B, it's still related to the representation, but I think under B, there might be some angle where we could argue it's required, explain a matter to the extent reasonably necessary for the client to make informed decisions regarding the representation. I feel like that's might be the way to weave in the requirement here, given the impact it might have. So we talked about it before, but in looking at it again, I think Eleanor's right that there might be a way to.
I mean, editorially, I think this says something about the thing that we're talking about is if you had to communicate it to the client, you probably really wouldn't want to. Right.
Yeah. I mean, because the client might view you as disloyal, right? Or the firm is disloyal.
Right.
That doesn't mean you are under the rules, and
shouldn't they be similar though? Shouldn't they be in the same ballpark, those two things?
If I were the attorney, not the expert, but the attorney representing the client, and I found out, I would be livid.
Yes.
If it somehow didn't come up in the conflict check or no one ran it by me, I mean, can you imagine?
Yeah.
How embarrassing.
The opponent, you would be so happy. I mean, you could just go to town, right?
So, well, it's probably a 1.4 issue, right? I mean, is it material, a significant development in the representation? So I think there could be several rules.
I mean, I could envision a situation where there could potentially be an expert witness opinion that is not
right
hugely
Well, and-
material,
and
but
actually,
I think
I-
there would have to be assumption that it could potentially be.
Yeah, I want to look at 1.4 again to see if that's limited to the particular representation too. Meaning, you'd say, well, that's not about this case, that's about a different case, so I don't have to disclose it. I don't know, it seems like a stretch. But yeah, so we're all pretty uncomfortable. We all want to dig in a little further and perhaps change this result, depending on what our research shows us. So why don't we, the next item on the agenda is the conversion clause, but I'm actually thinking, why don't we do that last? Why don't we move to the arbitration advisory that Elizabeth is going to talk about, 22 OXB. Are you excited to talk about that?
Sure.
Okay. Why don't we do that next? Because I think the conversion clause is a bit of a big conversation. Because the working group sees things several different ways, and we just want to bring that to the committee and see where we go with it. So let's move to item G1, Arbitration Advisory 22 OXB, determination of a reasonable fee. So Elizabeth, it's all yours.
Thank you. So the purpose of this proposed revision is to include language that is covered in the Shepard-Mullen decision as to the attorney's burden in seeking quantum merit where the fee agreement has been voided due to an ethical breach. So as everyone knows, in Shepard-Mullen, there was an undisclosed actual conflict of interest where the law firm represented an opposing party in the same litigation that it represented JM Manufacturing Company. And as much as I would have liked to include Justice Chin's reasoning in this revision, the language is limited to what the majority opinion included in the opinion with respect to that duty, including the fact that determination of the quantum merit is a matter of discretion to be exercised in light of all of the circumstances, with a not all-inclusive list of those types of circumstances, and requiring the arbitrator to be satisfied that any award doesn't undermine the incentives for compliance with the rules. And so it includes language expressly from the opinion that to be entitled to any measure of recovery, the attorney must show that the violation was neither willful nor egregious, and they must show that their conduct was not so potentially damaging to the client as to warrant a complete denial of compensation. The client is under no obligation to present evidence that it was injured. That's the primary goal of this revision. We did also update it to include the PESH, a citation to the PESH decision and new references to the new rules of conduct where, oh, I see I missed at least one. I'll have to go through it, but most, I think, of the citations to the former rule numbers have been changed to the current rule numbers. I see at least one reference to Rule 3-500. So considering that we're using the language directly from the Supreme Court opinion, I don't anticipate that this would be controversial, but one never knows.
Yeah, and for what it's worth, I think this is very useful for fee arbitrators. It's right on from Shepard-Mullen. I don't think it's controversial either. I do note that on page 11 of the red line, there's where it says the client is under no obligation to present evidence that it was injured. There's a cite to Shepard-Mullen without a page, and I think we should pinpoint that.
Yes, I agree.
But those are things that we can politely ask staff to clean. Are there any substantive points, areas of disagreement, or anything? Joel?
Yeah, I can't remember when I read this over before we talked, or I talked to Eleanor, is there reference in this made to, burden of proof, arbitration advisory? I think it's.
Joel,
I'm
Joel,
sorry.
can you speak up? Can you get, I'm sorry, we're having trouble with your
Yeah,
microphone.
I don't know what's going on, but anyway, is there reference made in this to the burden of proof arbitration advisory circa about 1996? Go back to the heading that said burden of proof.
Yeah, you added one reference. I'm not sure if that was, I did incorporate your proposal referring to a
Is that in there?
other opinion, but let me check if that was it.
I think the 1996 arbitration advisory was in the prior version of this opinion too. So
Oh, I see.
Does that-
Yes, yes, it
Does that
is.
talk about the burden of proof?
It, unfortunately, I can't get on the internet, so I don't have the page numbers, but right at the first paragraph, under the heading, attorney has the burden of proof to establish a reasonable fee, there is a reference to arbitrator advisory 1996-03.
Okay.
And that was previously in the advisory.
Yeah, I think that's all an arbitrator really needs to know when a question arises, whether an arbitrator is correct in putting that burden of proof on the attorney.
Yeah, I think this is particularly useful because typically if the entire agreement is voided, that should be being done by the trial court, not the arbitrator. So that was one of the big issues in JM, was that JM challenged the arbitrator's power to rule on that matter, and the trial court wouldn't rule on it and send it to the arbitrator. And then the Supreme Court reversed and said that the trial court should have been the one to determine whether the entire agreement was void, since they were not challenging any particular provision in the fee agreement. They were challenging the entire fee agreement and argued it should be void for the failure to disclose these material conflicts. And so I don't anticipate that this is necessarily an issue that's going to come before the arbitrators routinely, because it's oftentimes going to be handled by the trial court, which is why I think it's actually still very important to have this guidance for them, since it's not something they're going to be doing on a day-to-day basis. It's really important for them to know what the parameters are, and not just apply the other standard analysis that apply when a contract hasn't been voided. I mean, some parties, I would imagine, might stipulate to allowing the arbitrator to make that determination and not go through the litigation process.
And even more so, because the arbitration advisories have use all over the world, but for MFA arbitrators,
right,
that will have never even hit the Superior Court, and the arbitrator themselves will have to make that determination.
True.
So this is incredibly useful for issues that are going to be in front of fee arbitrators. So I think these are great revisions personally. And I didn't see anything that was confusing or off, but that's just one set of eyes. Anyone have any other thoughts on this? Yes.
So can you remind me the impetus for this opinion?
So
Advisory, I realized, I think
yeah.
it started before my time.
Sure.
Who's on the committee?
I cannot remind you of that.
I can.
Because okay,
But-
Elizabeth can.
Yes, the lead can.
Again, so, I mean, the advisory is quite old, so
Right.
it's been around for a long time, but Brandon and I are on the committee, but we look to our trusty friend Joel Mark for his expertise in this, since Joel was involved in the original advisory, and the impetus was that I represent JM Manufacturing Company. It's one of my clients, and when the matter, I wasn't on, at the trial level or in the appellate proceeding, we got hired after the remand by the Superior Court. And even in our own case and in cases subsequent to that, you know, it's kind of a new world order, and we have to educate even trial court judges on this portion of the Shepard-Mullen decision. And I felt it was important to keep, to provide that language from Shepard-Mullen decision to arbitrators because it is so critical. And, you know, it's, the analysis is going to change depending on the severity of the ethical breach, in my view, when the arbitrator is looking at all the different factors. But Shepard-Mullen made it clear that that onus is on the law firm to, it's very, one of Justice Chin's reasoning was, hey, the client, these are not things that the client can necessarily point to a dollar amount that your breach of loyalty hurt me in this dollar amount or in this way, right? Because the breach of loyalty, like we were discussing on the last issue, is really a really big picture issue, and that the onus should be on the law firm to prove that it didn't hurt or wasn't going to hurt, there wasn't a risk of hurting, whatever the language is that I've included here. And I just feel that because of the gravity of the situation in the Shepard-Mullen case, I mean, in my view, Justice Chin's analysis was correct, and there was enough evidence even at that level of at that stage in the proceedings to show that this was a really egregious violation of loyalty and violation of the rules of professional conduct. But in discovery after remand, it became even more apparent, the facts only got even stronger, that this was really egregious. And so, you know, I think typically things aren't that egregious, but of course they are sometimes. And having this framework for arbitrators who aren't dealing with these types of issues on a daily basis, even if they were, it would be important, but it's even more so when they get this kind of unique fact pattern. And I think a high level of client protection is really warranted when you're dealing with those types of egregious violations.
Yeah, and the Supreme Court of California doesn't dig into these issues all that frequently. So when there's sort of this landmark type of decision, it should be incorporated in the arbitration advisories that guide the attorney-client fee dispute arbitrations for sure. That's the impetus, as I understand it.
Yes.
Thank you.
Sure. Any other hands or comments? Because the goal here would be to vote this out for public comment. I would suggest that we would ask staff to, you know, clean up references to old rules, maybe catch a couple sites that might be off or things like that. But unless there's more substantive comments, maybe we vote on sending this out for public comment subject to staff revision. Anyone want to be heard first? All right, then I move, put it out for public comment.
Do you
I'll
have a
second.
preference on the time of public comment?
Oh, has this ever gone out before?
No.
Yeah, well, is there a rule, like, what is the guidance for long or short public comment?
So the guidance used to be 60 days for round one and 30 days for round two.
Okay.
That being said, we just extended a 90-day public comment 30 more days because we didn't receive enough public comment. I don't think this is very to my mind, and I don't think this is very controversial. You're just stating existing law. So perhaps 60 to give people an opportunity, and then I think that would allow for this to be brought back at the September meeting with enough time for possible revisions as needed as well.
That sounds reasonable. 60 days? Let's do that. That is my motion.
I'll second that motion. I think 60 days is appropriate because the pushback is going to be the argument on the one hand that, well, it's no harm, no foul. The client got the benefit of the services. On the other hand, you've got the prophylactic effect of a violation and dealing with it in considering whether the fee has been properly earned. And I would like to see a robust discussion of that issue when it goes out to public comment.
Great, I agree. And one side of that issue has a Supreme Court decision on its side. All right, so let's take our vote.
Okay, taking the vote. Brown,
Yes.
Bradley,
Yes.
Shivers,
Yes.
Guzman,
Yes.
Mark,
Yes.
Rios, O'Reilly,
Yes.
Poindexter,
Yes.
Ravi,
Yes.
Starr, and Krieger.
Yes.
So
I didn't hear Mercado, but you cut out at a moment, so I'm a yes as well.
You're a yes, thank you, Eleanor. So that's unanimous, the motion carries.
Great. So I'm going to suggest a brief break, and then we'll come back and talk about the conversion clause draft for 5.5 hours. Okay? All right, 10 minutes?
For the 5th time. Okay.
All right. All right. Welcome back, everybody. I misled you as to the next item. We're going to do theoretically a short discussion first of some proposed rule amendments. And I'm going to let Erica talk about this.
Great, thank you. So as you can see from the agenda item, this was provided by the current president of the California Judges Association. And in the request, there was some context provided, but essentially what they're asking for the committee to consider is proposed amendments to Rule 3.6 and Rule 4.1. Rule 3.6 is the trial publicity rule, and 4.1 deals with truthfulness, essentially, in statements to others. So I think it'd be helpful to get initial thoughts as it relates to the proposed changes including, you know, whether this should be addressed in these rules, whether it's addressed by existing rules. And then my personal goal would be to have a group that can consider this more thoroughly, looking at, you know, how this has been addressed in other contexts through sanctions, contempt, and discipline.
Okay. So I'm trying to see if anyone has any thoughts. You can all, even if you didn't have a chance to do the reading in advance, you can see now the entirety of the proposed changes. And one point to perhaps consider is that it strikes me that the proposed changes may be duplicative of things that are already covered by 8.4, although I'm not certain of that, and I welcome discussion on that, meaning that these are already prohibited acts. And certainly the proposed change to Rule 4.1 seems to also be a violation of the BMP code, the duty to use means only consistent with the truth, or 6148, or no, 61, anyhow, I've lost it. But we have to talk about whether these are filling gaps, or just would this be reiterating prohibitions that already exist? So I welcome people's initial reactions to whether this is a good idea or not.
They both look like good ideas to me, probably to Judge Marchand as well. But I think they address an issue that we've seen.
Joel, we're having the same problem with your microphone. If you could just speak closely to it, I apologize.
I don't know why. God, kiss the thing. I don't know why we shouldn't address this issue. It's certainly being addressed in front of our eyes. And it would be, I think it would be a constructive rule, both of these, to have that would prevent some of our attorneys who have run astray from doing so.
Well, I wonder if, is it 60680E? Is that the one? I'm trying to remember which one. 6068, right?
Yeah, so there's a few
Yeah.
subdivisions in 6068.
Right.
That
And I'm
this
just
could
wondering if
touch
it
on.
already is prohibited, are we, would it be adding benefit to do these rules rather than just enforce the existing rules more diligently?
So perhaps for a working group to consider is whether an opinion could say that engaging in this type of misconduct is violative of those existing rules, as opposed to, if that's their determination, as opposed to creating more rules that address the same conduct.
So do you not think that CPJ, maybe? CJA knows those rules? So there's some reason, it's not like they don't know those rules. So why do they feel this is needed?
That's a good question.
Because it's not like they don't know this.
They know these rules,
Right.
yes.
So
do,
they
yeah.
somehow feel those are not strong enough, or what? I mean, I don't know, but I think that's.
Well, I don't think it's correct that we're creating a new rule or duplicative rule or whatever. For instance, 6068E is also covered in substance by the rules of professional conduct.
True.
That seems to have a good effect, as far as I know, on implementation of both. So I don't see it as a reason not to go forward if it's otherwise not addressed in the rules of professional conduct.
I think the rule 4.1 edition is probably confusing because subpart A of 4.1 just is basically the same rule, I think, but to statements to third persons, which is pretty broad. So I would suggest that change go into a comment, just to clarify that statements to third persons would include the media or social media.
So it's interesting, 6068E B requires attorneys to maintain respect due to the courts of justice and judicial officers. It would be interesting for me to know if.
We can't hear you, Brendan.
Oh, I'm sorry. It would be interesting for me to know if 6068B, requiring respect due to the courts and judicial officers, has ever been enforced. Do people do anything with this law on the books before we talk about another rule? I mean, I think I'm assuming as read that nobody objects in substance to these concepts. The question is just like, where's the best place for them and how to articulate them? And do we need to say them twice if that is repetitive?
Well, I'm not sure it's saying them twice. I mean, if you literally read 6068 B, with great respect, I think that the judicial officer's family ought to be taken out and on.
Yeah.
So I don't see it as, if it is a duplication, which it probably is, I'll concede that. I don't see it as being something that is a superfluous duplication. I think it's, if anything, a clarification. And it gives something specific for the state bar to use to address what, unfortunately, we have seen before our very eyes has become a practice in some circles.
I agree, and I think it takes it away someone's argument that, well, it's not clear that this conduct fits under the rules of professional conduct, or I think it's useful to make an express proclamation that this is violative of 6068. Since the rules are, what triggers disciplinary conduct.
Right.
Then it's kind of been adjudicated that that is a violation, assuming that it can be proved that the violation occurred.
So one other thought is to examine whether or not judges' existing tools of sanctions and contempt are insufficient in this regard. Would this be helpful to the situation? I mean, I'm getting the sense from those that are speaking up that they think it is actually a good idea. Does anyone feel otherwise?
Now, Brandon, you actually planted in my brain just with that comment another reason for doing this. I'm thinking about the situation of, for instance, Judge Marchand, whose trial we've now all been listening to, or I have anyway, where he exempted himself from the order that he issued to the parties. And he felt he had to do that, I assume, because he didn't want to make it look like he was incapable of handling the trial or creating some additional stigma as a neutral judge where he would be adjudicating his own interests. But still, if a lawyer were to do that in the courtroom, even in the absence of a specific prohibition on lawyers to comment about the judge, I think it would be appropriate for the state bar who regulates that lawyer to have a tool to address it, because it's clearly improper.
I think it also gives a judge a stronger reason to make a referral to the state bar where warranted, either something that's happening in their own courtroom, or if they have knowledge of another one, something happening in a different courtroom.
So we should, I think, have a working group then to look at this proposal make a recommendation generally, and then even more specifically as to language. I'm a little, it catches my eye that the last words in the proposed revision of 3.6 are, you know, puts them or their immediate family in jeopardy. Should that be more specific? Should it be at risk of physical harm? You know, I don't know. That would be something for a working group to look at. And then there are First Amendment issues that I'm not really qualified to opine on that I would assume would be the defense of everybody who breaks this rule. But I don't know if they have real defenses there. I'm sure that's been dealt with in other areas in the rules. But could we have a couple volunteers for a working group on this to think about it and sort of report back at our next meeting? Cassidy? And
Yeah, I guess I should have been the digital hand, but yes, that's my hand.
I saw your hand. Either way, we're good.
All right.
All
Yes.
right. And Vakita. All right, so that's 3. Awesome. Okay. So I look forward to hearing what the working group thinks we should do at the next meeting. So let's turn now to, I think, the final agenda item, which will take up the next 5 hours. Look, this is an interesting posture because everybody on the working group is really giving this their best attention. Everybody's giving it their good faith perspective, and we have areas of difference. And I will do, on the conversion clause, I'll give a little history lesson at a high level. I proposed the first draft of this in 2020 because in my practice, I routinely see clients whose fee agreements for contingent fee representations contain language that says, if you discharge me prior to the, you know, end of trial or whatever, you owe me my hourly rate times my hours worked. And I have seen countless clients who wanted to fire their lawyers, that had complete breakdowns, maybe abusive relationships with their lawyers, but didn't fire their lawyers because they were afraid of this. I've seen, and then we've seen other, you know, the conversion clause has to do with termination of the attorney-client relationship. There's also conversion clauses keyed off of settlement recommendations, you know. The attorney thinks you should accept a settlement that you're not willing to accept, or the client is not willing to accept, and there are countless permutations on, if you make me go to trial on this and we do worse than the settlement, you pay me my fee against the settlement that was available, blah, blah, blah. So the first draft, or the initial drafts that went around on this, looked at it on a case-by-case basis, but with respect to conversion clauses keyed off of settlement demands, found that that's never going to fly. There's no ethically permissible way to do that. You know, the settlement decisions belong to the client, and conversion clauses keyed against settlement are going to impermissibly infringe upon that client right to determine the goals of the litigation. And that was not controversial with the committee as then constituted back in 2020 or 2021. The area that was a little more fraught had to do with conversion clauses keyed off of termination of the attorney-client relationship. And my initial draft suggested that those are subject to, they're rarely going to survive ethical scrutiny. They're rarely going to be permissible. But we admit that there might be some circumstances where they could fly and pass muster. And we did a hypo that was routinely called like a Rube Goldberg machine of trying to make it sound like this is a great scenario. You know, you've got sophisticated client with in-house counsel, blah, blah, blah. And people thought that was just unrealistic. The drafting group at that time was me and Joel and Ken. And Ken is no longer on the committee. And we formed the point of view to go even further and really shut the door on conversion clauses. We came to the point of view internally that any conversion clause that purports to entitle a discharged attorney to more than quantum merit is ethically impermissible. And Joel drafted a memorandum that's in your materials advocating that point of view. And that actually became the unanimous point of view of Joel and me and Ken at the time. But it met with a good deal of resistance, and I'll say good faith resistance in the committee. I was of the opinion that my draft, which kept the door open a crack, was better than nothing. And maybe it could get passed. Joel, and I respect where he's coming from, thought, no, if it's wrong, it's wrong. We should go for a clean opinion that says you can't do this. Then we invited more input a couple months ago, and Sarah and Eleanor came up with an outline here for a more flexible conversion clause opinion that would permit conversion clauses in greater measure. So what we have is 3 options in front of us. And the problem here is that, usually when there's a lack of consensus on a working group, things just sort of stop moving. And I think this is a really important public protection matter. And I know we got a lot of public comments suggesting this is not a real problem and what are we doing? And Joel and I, in our practices, have seen this and the negative impact of these conversion clauses on real clients year in and year out. So we think it's important that we continue to try to reach a consensus and have a useful draft if that can be gotten. So, since my draft was sort of the middle ground, I would invite Joel on the one hand to talk about his preferred version, and then I would invite Sarah and Eleanor to talk about their more flexible approach. And I want to get the sense of the committee. How can we move forward? And there's one other thing I should mention, which is that Deepika is going to be joining this with she hasn't been privy to this long tortured history, and hopefully bringing a fresh perspective on this as well. But I want to get a sense of the committee's view on should we move forward at all, and how, in what direction. We can do straw votes, we can just chat. But so with that, I will toss it first to Joel. And Joel, I will remind you of the microphone issues we've been having, so I don't have to interrupt you to say so.
I'm getting as close as I can, Brad. How am I doing? Okay?
All right, perfect.
All right. I won't repeat everything. I would commend everybody to read the response and report. I can't remember exactly what I called it, about why I think we should take the position that it's not permitted. I think the Fracassi case says that it is a disincentive in violation of 1.16 that against a client freely exercising the right to terminate the attorney-client relationship. It further states in Fracassi that in a contingency case, because the contingency hasn't yet occurred, there is no basis in advance of the occurrence of the contingency to calculate what the reasonable fee that the attorney is entitled to. And further goes on to state that after the occurrence of the contingency, it is readily calculable, even in the case of the courthouse step settlement, which is the example that they use in the case. If the client is fired with the attorney is fired with an offer in hand within the attorney, second attorney accepts, or the client accepts, clearly the attorney has a very good case for almost the full value of the contingent fee on a reasonable fee basis. So the protection is there for the attorneys, and the public policy consideration prohibitive. Since then, in the past several months, in 3 of the cases that I have been involved with, either with a request that I provide some expert opinion, or in one case, mandatory fee arbitration, which I was given by the committee recently, those all 3 had conversion clause issues, and none of them seemed to pass muster in my mind, even giving thought to could it possibly be what hypothetical might make it so? And then the final comment that I've made to Brandon some time ago regarding his middle of the road hypothetical, after much discussion, Ken and I and even Brandon agreed that it didn't get us there. And what good were we doing by encouraging people to find ways to get around it in some way? If someone is smart enough to do that, then a court is free to disregard our opinion, as the courts have done several times that I'm aware of in the past. But to encourage more people to take advantage of clients by claiming they're sophisticated or no harm, no foul, or they really were cheating me, they didn't tell me all the truth, all the kind of factors that are already built into a contingent fee, which is normally going to be larger than hourly fee because of the contingent risk. I just didn't feel comfortable encouraging that, and I ended up with a position, the feeling, and I told this to Brandon and other members of the committee, that unless we have a clean opinion, we can agree on a clean opinion. Unless I could be convinced otherwise, I would be inclined then simply to withdraw my endorsement of the opinion and vote no. And I'm perfectly willing to live without. I've been outvoted by the committee before. But I am concerned that after 4 years, we do need to bring this to a vote one way or the other. It's time.
Thank you, Joel. I would ask, I don't know if Sarah or Eleanor wants to talk about the more flexible conversion clause outline you guys prepared, but I would invite you to sort of chat about your point of view.
I can start, and it might be helpful if you want to share the screen with the outline that Eleanor and I worked on. And one thing is, we're getting there, that I want to point out is that Fracassi doesn't address a conversion clause that addresses a situation where an attorney is discharged without cause and is arguing that the attorney should be entitled to the full contingent fee in that situation. And the court finds that no, the attorney in that situation is limited to quantum merit recovery. But so that, I don't think that decision addresses at all with the permissibility, whether a conversion clause itself is permissible. And the approach that Eleanor and I outlined here is a proposal to have an opinion that doesn't necessarily have the hypotheticals, because we think it's really a case-by-case basis whether a conversion clause would be permissible. And like the Colorado and some other ethics opinions that have addressed this issue without having a hypothetical, they just went over the relevant factors that the attorney should consider. And that's the approach that we would recommend be addressed here. And so this outline that's on the screen is intended to address some factors that we believe are relevant to consider, but we don't agree that across the board, any conversion clause that is more than quantum merit recovery would violate the rules of professional conduct or ethical obligations of the attorney. And we think there are many different situations where a conversion clause might be permissible. And so, this outline goes over those elements. I don't necessarily know that we need to go one by one, but where it's triggered by the attorney discharge or an attorney withdrawal in compliance with the rules, generally where it's contingent upon recovery, so the attorney wouldn't be entitled, the conversion clause, attorney wouldn't be entitled to payment under that unless the client does receive recovery. And then just in compliance with the rule that the fee overall must not be unconscionable. And one element that many of the other ethics opinions, and Douglas Richmond drafted a pretty great article on this that Ken in the working group shared earlier, and that he finds and other ethics opinions find is that there should be a cap. It shouldn't exceed the original contingent fee amount in any situation. And that, if it's operating as a penalty for the client to refuse to settle that would not be a permissible situation. So we agree with the, overall opinion that where it's, triggered based on the client's refusal to settle, that would not be permissible. However, we think in many other situations, a conversion clause would be permissible. And then let me just pulling up on my screen because, sorry, given the passage of time, I just want to look at, you could scroll down a little bit more. Right, I'm a little more than I wanted. Hold on a second, let me just pull up. And so those are the main, I think those are the main factors. The final factor that we talked about too is just informed consent from the client to the conversion clause. And, not that it's necessarily always required, but having a sophisticated client is something that's more likely, particularly where in many situations, we believe the client might be the one requesting the conversion clause to have some sort of certainty. We think it can provide some client benefits as well. And then we went over some additional factors that might, lend support to whether a conversion clause would be permissible. And they're all really factual based, or might mean that it's not permissible, but where it's subject to negotiation, where the client is the one insisting on, where the lawyer might be the only one willing to take the case. And then we go over some factors that would tend to make a conversion clause unethical, and outline all of those. So whether it's triggered by discharge of the attorney with justifiable cause, triggered by the withdrawal of attorney without justifiable cause, the refusal to settle I went over. So I think those are kind of what we've outlined here in terms of relevant factors that we think should be considered. But I think our overall impression based on our review of all the authorities is that it's not prohibited altogether. It could be permissible in certain situations, and it's really a case-by-case situation. So it doesn't lend itself to, an easy hypothetical, because I think there's more than one where it would be permissible. So I think it's better to have a more flexible approach here. So I'll pause because I've been talking for a while and I want to see if Eleanor wants to weigh in.
No, I think you covered it pretty well. I mean, I think it'd be useful to get the impression of the committee and whether or not it, would be helpful just for purposes of grappling with it to prepare hypos, which we didn't do because, we didn't want to go down that road and invest the time if people were still kind of deadlocked. But if it's useful, I think we could probably spend some time doing that to kind of move things forward.
So there's 5 committee members who are not involved in the working group, right? I don't know. So the working group, we've already been hashing this around back and forth. And so, we don't need to listen to each other talk. So we really do welcome other points of view on this, if there are any.
Well, what was the committee's thoughts on what Eleanor and Sarah provided in terms of, is it robust enough to handle you? I guess Joel seems to be, and is it important enough to not put a space for people to wiggle?
Yeah, so I mean, there have been 4 of us working on this, and it's really right down the middle. Joel and I are not comfortable with the case-by-case analysis. We have substantive disagreements on many of the individual outline items, but moreover, Joel and I are really concerned about putting an opinion out there that gives people a roadmap for how to make conversion clauses work. The silence right now might be better, because right now, it'll be argued on a case-by-case basis whether this is ever permissible or not. That'll be. I don't want to endorse the idea of conversion clauses when, in fact, I'm personally against it. One of the other things here is that it's true that there's a lack of authority directly on point. Now, Joel's memo argues that that there's case law from which we can infer that these conversion clauses are not acceptable.
Brandon, actually, I argue more than that, and I would commend everybody to read the majority opinion in the Fracassi case.
Yeah.
And at page, I forget, headnote 5, in summary, we hold that an attorney discharged with or without cause is entitled to recover the reasonable value of his services rendered to the time of discharge. Cases to the contrary, commencing with a whole line of cases, are overruled. Those cases were the ones that had previously held for about 100 years that you had a cause of action for a contract amount in a contingency case. We further hold that the cause of action to recover compensation for services rendered under the contingency contract is not approved until the occurrence of the stated contingency. In light of these rules, it seems clear that there is no present controversy which would justify the court exercising its discretion to entertain declaratory relief to the contrary. And to highlight the point, Justice Sullivan, in his dissent, says that what the majority is doing is exactly what I'm saying it's doing. That the client's discharge of an attorney without cause does not constitute a breach of the contingency contract, so as to make the client liable for damages on the contract. Sullivan's dissent says that the majority has ruled that a contract existing as or purporting to entitle the attorney in the contingency case to fees upon discharge is no longer good law.
So Joel and I want the same outcome here, but I do acknowledge the criticism that Fracassi's dealing with a default situation, not an expressly drafted conversion clause. It just doesn't address what we're talking about because it wasn't before that court. One interesting issue here has to do with the role of an ethics committee like this. Because there are the point of view that our job is to summarize existing authorities, and we can't go further than that. There's also a view that ethics committees are precisely who should go further and step into gaps that are not addressed. So from my point of view, recognizing the limits of Fracassi differently than Joel does, and even more in line with where Eleanor and Sarah are, I'm still comfortable as an ethics committee saying it is our view that this is impermissible. So that's one issue that we all have to wrestle with as to how we proceed. Deepika, your hand is raised.
Thanks, Brandon. And as the newest member of this working group, just thank you to everyone who helped prepare these materials. I found them very helpful in kind of getting my arms around this issue. I do have one question and then one suggestion. Sarah and Eleanor, you mentioned, whether it might be helpful to create additional hypos to kind of flesh out some of the ideas that were expressed in the outline that was just up on the screen. And I noticed that the draft opinion did have 5 hypotheticals in it. I was wondering if you meant like modifying those hypos to fit within the outline or entirely new scenarios that would flesh out some of these principles.
So I think, just given the timing, I forget, I know the initial draft of this opinion, I think it was the final hypothetical, if I recall, and maybe that was the 5th one that you're referring to, that did address a situation where the working group felt a conversion clause would be permissible. And that was, I think at the time, when it was Joel, Brandon, and Ken on this working group, and the 3 of them had come up with that hypothetical. So that's the current kind of situation of the hypotheticals. I think what Eleanor and I had in mind was maybe coming up with additional hypotheticals, perhaps based on this discussion, if people felt that it really is a case-by-case basis that kind of met the factors that we were providing in that outline. So that's what we meant in response to your question. But at the same time, I also think this could be an opinion done without necessarily having hypotheticals.
May I express in his absence King's frustration with that comment? and one which I share, which was at the encouragement, actually, of early meetings discussing this draft. We did, and Brandon did the lion's share of the work and drafted 5 hypotheticals. And over the next good year, perhaps longer, we as a working group worked through each one of those hypotheticals. And for 4 of them, we were absolutely clear that they would have to result in a no, you can't do this. And as to the 5th one, we still felt that on balance, you couldn't or shouldn't do it because it was just so attenuated with all the facts in it. And so we came up with a clean draft. And when that was met with resistance by this committee, perhaps a year or so ago, that, well, maybe we should go back and consider some additional hypotheticals. It was Ken and I both said, fine. Anybody who wants to suggest a hypothetical that they think will pass muster, please do it. And we have not received that yet. And that was Ken's frustration when he handed this over to me and said, it's your problem now, is that, yeah, if you think there ought to be more hypotheticals, put one together. Let's take a look at it. But if we can't after 4 years plus, then let's move on.
Well, and I'm going to call on Dan in 1 second. The only thing I would say in fairness to everyone is that it hasn't been 4 years of round the clock effort. We're a glacier. We move at our pace. Joel and I have been trying to move it forward as much as we can. I do invite people to bring specifics. I'm really pleased with this outline. I disagree with a lot of the outline, but I'm really pleased it exists, right? Because we can actually specifically disagree. And I would really invite hypotheticals that people think where conversion clauses are ethically permissible, so we can dig into the fact patterns and see where we agree and disagree. So I'll call on Dan really quickly. Oh, and Eleanor right after Dan. How about that?
Okay, this is a question maybe for Eleanor and Sarah, because I'm trying to follow the logic, based on what I perceive to be the black letter law of plaintiff or a client terminating a contingent fee lawyer. And as I understand it, right, so you have the unfettered right to do that. When you do that, quantum merit is your exclusive remedy. No part of the contract, the fee agreement, is enforceable. What would be the basis, or is there one, for any provision in the agreement to be enforced?
I mean, I can answer what I would think, just arguing against my own position, is that black letter law is a default where there is no conversion clause, right? And liberty of contract, we can contract around that and come to an express agreement as 2 fully functional arm's length parties that if I fire you, you can have my firstborn, right?
I think that's right. I think the difference here is like, I mean, as I view it, it's like one group is taking a sort of paternalistic approach to this, but it doesn't exist in the black letter law. I think there's a freedom to contract issue that at its heart is bothering me. And I think, the reason we didn't go, or at least from my reason for not drafting the hypos, was because I thought we could all imagine what they would be based on the principles we put together in the outline. And it might be more productive to walk through the outline and get people's views to see how we can structure a hypo that addresses the concerns of the principles we put forth, rather than, drafting one that meets every requirement we have in the, that's attenuated and is going to get, objections for that. If we can talk about the principles and what people think about them. And, if we all agree, it's worth trying to draft hypos that address people's concerns, we can do that. But Joel, I appreciate your frustration, but it didn't feel worthwhile to go and draft one that, is unlikely to exist in real life, and address the concerns of the committee.
I think that's a great idea. I mean, Eleanor, do you want to just sort of walk down the list of your outline a bit and we can chat about what we agree with and don't?
Yeah, we can do that. I mean, Sarah, I missed a group call, so I don't know to the extent this has been done with the committee, and I wasn't present, but, chime in if we've already had discussion about this and we understand what the concerns are and why people objected to any of these. I mean, I think everyone would agree on the discharge principle. To me, that seems like, consistent with the views of Joel's views on this. Right, so I assume that doesn't raise any concerns.
Actually, I'm not clear. Are you suggesting that if you find out your client's been lying to you and you quit, you can still get paid?
Sorry, thank you. I was looking at that and misinterpreting my own, our bullet. So thank you for pointing that out. I think what we're saying is if the conversion could be triggered by a discharge of an attorney or attorney withdrawal that is consistent with the ethical obligations of the attorney.
And so I just know that Joel and I have voiced, like in our working groups, that we've always viewed that as a contingent fee lawyer, I've always viewed that as just the cost of doing business that is supposed to be accounted for in the risk premium of the contingent fee. That's my counter, but yeah.
I mean, it assumes that, I guess there are just some assumptions baked into that.
Yeah.
But I don't know that it's worth getting into the weeds, like even if the risk premium is there, as a contingency lawyer, if you don't want to wait or bet on somebody else's work, why can't you contract for that?
Would you repeat
One
that?
of the rules says you can't I think we're starting from a position that there is black letter law saying you can't, and I don't see it.
Well,
Go ahead.
I'm sorry, I didn't mean to interrupt.
You go ahead.
No, I mean, your first bullet point is elements of a potentially permissible conversion clause. And it discusses whether it's stronger if the withdrawal is for good cause or not. And
it's broader than that, but we can focus on the good cause thing because that's narrower. So that might be a healthy place to focus in terms of coming up with a hypo.
Okay, but then if we're going to, I thought we were going to, I mean, what do you do with the holding union for Kasi? In summary, we hold that an attorney discharged with or without cause is entitled to recover the reasonable value of his services at the time of discharges. Basis of the contrary are overruled. We further hold that a cause of action to recover compensation for services rendered under a contingent fee contract does not accrue until the occurrence of the stated contingency.
I'm having trouble hearing. I'm really sorry. But I am having a little bit of trouble hearing you, and I don't have it up in front of me, but I can pull it up.
Okay, but for Kasi holds, it says it has two holdings that you're limited to reasonable value if you're discharged with or without cause. Number one, up until the time of the discharge. And number two, in the contingent fee case, your claim does not accrue until the occurrence of the contingency. And that's at the time when the reasonable value can be calculated.
Yeah, so I think I think we have that latter one in the outline.
But here's the point, is that whatever you can say about Kasi, it does that it might not be on point. It says at the end of that paragraph stating its holding, whether there might be some circumstance in which a declaratory relief action might properly be brought by an attorney need not decide. The facts presented cannot support such an action. So, all right, it would seem to me that our job, if we are going to address Percassi's invitation to present facts that might support an action prior to the happening of a contingency and on some basis other than reasonable value under the Kazari's case and the Percassi case, it's up to us to articulate that. And we haven't. And in the absence of being able to do so, I would say that the state of the law is the holding in Percassi.
Well, Joel, I think the response there really just keeps going back to Fracassi. Fracassi isn't about a
Doesn't deal with
conversion
one.
clause. And does a conversion clause mean it's not really a contingent fee agreement?
Kind of a modified one.
Right,
Yeah.
as the way that Fracassi is treating it. And I think my concern is paternalistic or parentalistic or whatever we would say. It really is. And so are so many of the ethical rules. But, you know, I think that what I see is these clauses, sometimes you're going to litigate this issue, right? But more often than not, you get a client and you say, why did you stick with this sinking ship of an attorney? What were you thinking? I couldn't fire this guy. I didn't have any cash to pay him, and there's this huge penalty clause in there. And so it is certainly, I don't disagree. And that was why my initial draft said maybe there's some circumstances with super sophisticated clients and everything's on the table and fully understood. But there was sort of universal agreement that the hypo that I came up with to make a satisfactory conversion clause pass muster was super unrealistic. So anyhow, like, you know, we're stuck on Fracassi, and I understand everybody's view on Fracassi, and I kind of want to just move beyond that to our normative view of what we think our ethical senses are. And if we have any consistency of our ethical sense, then maybe we can look for the underpinnings of it. But I think we have a lot of disagreement even as to our ethical sense. I mean, liberty of contract and my parentalist view, they don't sit well together, right? Sarah. Oh, Sarah, I think you're muted.
I'm sorry, I just realized that. I also just wanted to flag the issue. You know, as a policy matter, I also just don't agree that conversion clauses are always harm the client, right? I think that's kind of the position you're operating from, that, you know, they're generally always harmful to the client, right? But I just don't think that's correct. I think in certain situations, it could be something that the client wants certainty up front, wants an agreement on up front. It also could be an access to justice type issue where otherwise attorneys might not be willing to take on certain cases if they can't negotiate a reasonable conversion clause. And so I don't always see it as a, you know, conversion clauses are always bad. You know, I understand we want to protect clients, and that's, you know, part of the role, I think, of, you know, as we're addressing a lot of these ethical issues, is consider protection of the public. But I just don't agree with across the board that conversion clauses always result in harm to the client. So I just wanted to make sure I address that issue, because I feel like that's kind of where a lot of the opposition is coming from. And I disagree with that.
So
Yeah, I mean, for certain clients, the benefit might simply be deferring the payment. I mean, there are all kinds of potential benefits, and including access to justice. But the more sophisticated the client, the easier it is to imagine the benefits.
So I appreciate that. And the access to justice issue was raised. This has gone up for public comment one time. And there were a lot of public comments talking about the access to justice issue. And it's interesting because I arrive at a completely different point of view. The access to justice issue operates from the assumption that there's a lot of people that can't afford hourly fees, and we want to incentivize attorneys to take these cases on a contingency. But if we're operating from the assumption that they can't afford hourly fees,
Right, how can
a
they-
conversion clause just means they can't ever fire their attorney, depending on the conversion clause. And so I find it even more troubling.
Right.
It's really interesting. We're looking at a lot of the same issues and just arriving at different conclusions. And maybe that means we're not going to be able to get off the dime here, because I appreciate everyone's coming at this in good faith. We're really reaching really different conclusions from the same issues. So that access to justice issue I found really compelling in terms of contrary to the idea that we should have conversion clauses to people who can't afford, for people who can't afford hourly fees. Because then it becomes just a massive penalty, as I see it in my practice, and maybe I'm only seeing the bad ones and not the sophisticated ones.
No, that's what I see too, and I'm look at it a lot of times from the firm side, and most of the time, to Sarah's point, the firm would be worse off under the conversion rate, but they would get paid sooner. And it's often the fact that it's there that prevents the client from moving on.
Mhm.
They may not necessarily get paid sooner. You know, you could have a principal that did not allow payment until the ultimate.
Wait, are you rewriting the contract, Eleanor?
No, I think Eleanor, because in their outline, they talk about the conversion fee is not payable unless and until there's a contingency.
What if the contract says it is? I mean, we don't want to be, in the middle of this negotiation. They're arm's length deal.
I appreciate your point.
The ones that I see
I hate to
certainly
keep
are.
going back to Percassi,
But
but it states that we've concluded that a client should have both the power and the right at any time to discharge his attorney without cause. Such a discharge does not constitute a breach of contract for the reason that it is a basic term of the contract implied by law into it by reason of the special relationship between the contracting parties, that the client may terminate the contract at will. Where do we find a basis against that language for making the client pay for it, exercising that right?
Joel, I'm with you, but I mean, again, that's a standard contingent fee contract, and I don't think anyone disagrees with Fracassi as it applies to a standard contingent fee contract. What always troubles me about these conversion clauses is the people, in my experience, again, and I understand there could be other, but in my experience, the clients can't afford hourly fees, so they go to a contingent fee lawyer, think they're getting a contingent fee agreement, but tucked into it is this massive penalty for terminating the attorney-client relationship.
Maybe that's a factor that gets baked into the outline, is their ability to pay the fee. And, maybe we've been talking about it in terms of client sophistication. But if a client lacks the ability to pay the fee, does it then become unconscionable because it operates as a deterrent to terminating the attorney? I mean, I can see that argument, and I would support it. I just don't think it's always present.
Right. So the fifth hypo that I came up with, that's in one of the old draft, the fully fleshed out draft, right? Talks about a negative contingency, blah, 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 the super sophisticated client and having in-house counsel. And it just has all the protections so that we can be sure nobody is really being penalized for exercising their right to discharge counsel. But even the folks that are in favor of conversion clauses in the public comment thought that was a really far-fetched hypo, just like not tethered to reality. I'm not sure how to proceed. This is interesting. I don't want to just make this go on forever, but for instance, if we go down the outline, no obligation to pay before the contingency or in the absence of the contingency, I think that's great. I'm fully on board with that. But the idea that a client's change in objectives could be a legitimate trigger for a conversion clause, again, I have always been of the sense that it's the client's case. Client determines the outcomes of the case. Those are not set in stone. The client retains the right to make decisions as things go forward. Maybe there's a counterclaim that, you do your fee agreement and it says, client, if you are going to do anything less than go for $10 million, you owe me my hourly rate. But then there's some counterclaim that puts the client in terrible jeopardy, and the client should be able to change their mind or respond to objectives. I always thought that was baked. I've always viewed that as baked into the risk premium of a contingent fee. I think other folks just disagree, and so I'm not really sure what to do with this, except kick it to Deepika to solve our problems with her fresh perspective. Yes,
Well,
Raquel.
Which is maybe just let's lift our head a bit. So because I'm trying to figure out if you have a contract and it makes a statement already about conversion, what's the issue? That is not enforced in the way that the clients agreed to?
I
Or
guess-
are we talking about contracts that don't have conversion being a part of it?
No, this is an express conversion clause in the contract,
Okay.
and our idea is, or sorry, not our, my and Joel perspective is that the existence of that term burdens the clients or infringes upon the client's rights in the rules of professional conduct, the right to determine the course of the litigation or to fire your attorney at any time. And
Just the mere having it because therefore you may incur a fee
yeah,
once
Yeah.
you trigger it.
right.
Okay. And
right.
so what you're saying is that contingency fee arrangements shall not have any clause about conversion.
That's our view.
And so a client then has the right to have a lot of different options,
Right,
to include walking away, and it's a wrap. There's no
right. And
there's no requirement to pay to do
Right,
that.
you always have an attorney always has the right to a reasonable fee
Right,
if a contingency occurs.
right.
But if the litigation is too awful, too upsetting to the client,
Right.
clients sometimes just want to quit. And that is awful for the attorney, but it is supposed to be baked into the risk premium in my mind. Maybe, and I understand the contrary point of view. Maybe the sophistication of the client is the key. I mean, most contingency fee arrangements were created
For low.
to help people that can't pay a lawyer
Right.
hourly.
And so Eleanor and Sarah's middle ground is there could be some circumstances where
It could fly,
it could happen.
but there have to be protections. So, Deepika?
So let me just
Oh,
weigh
sorry.
in. I would be on the side of not having any leeway, just saying there is no conversion. I just think if you're making a hard statement, you do have to make it. Otherwise, I think the statement that we make is not really helpful. So we're looking to give guidance,
Right.
and then it lets attorneys know whether or not they want to be contingency fee attorneys. Because there's no wiggle room.
I appreciate that. Deepika?
Could we also chat about the part of the outline that references the Oregon ethics opinion that not all conversion clauses triggered by a refusal to settle might violate the rules? I personally my reaction was that makes me uncomfortable, but I'm interested to know what others who are kind of worked on this for many years or others in the group think about that Oregon ethics opinion and how it might, relate here.
It may not shock you to know that Joel and I disagree with the Oregon Ethics Committee conclusion, but I will certainly let Sarah and Eleanor share their thoughts. Oh, maybe not. I can't tell what's going on here.
I can't, I'm trying to, sorry, this outline was prepared a while ago. I'm just trying to find where that Oregon opinion is referenced in the outline. I'm trying to pull it up on my screen to see
Page one, about 75, 80% of the way down. Consider Oregon ethics opinion that not all conversion clauses that are triggered by a refusal to settle violate ethics rules. So, I mean, and just,
Oh,
yeah, I'll let Sarah speak here, but, you know.
so I'll just say, yeah, I'll just say, I think that was an issue for consideration, but I do actually agree that a conversion clause that is triggered by the client's refusal to settle would not be permissible. But I also, one thing I want to say is that, because we were talking about this previously, I think in connection with one of the questions raised in terms of, the opinion that, conversion clauses just interfere with the client's right to discharge counsel and therefore are impermissible. But I don't think the conversion clause necessarily prevents a client from walking away, particularly where it's a corporate client or maybe a high-level executive retaining an attorney on contingency fee basis in connection with the negotiation of a severance agreement or something. I don't think that situation would necessarily prevent that type of client from walking away just because there's a conversion clause, as long as it's reasonable. And one of the factors we have here is that must not operate as a penalty. So I think the assumption that all conversion clauses operate as a penalty or interfere with the client's right to walk away, I just don't think that's true. That's a true assumption across the board. But yeah, I know we have this in here, consider the Oregon ethics opinion for discussion purposes, but I haven't looked at that in a while, so I don't recall what their analysis was, to be honest. Eleanor might have more, but I think generally, if it's triggered by the interference of the client's right to settle, that it would not be permissible.
So, Joel?
Yeah, the issue that we have, I think we've articulated in the past in our discussions, certainly I have.
Joel, I'm going to ask you to just really get intimate with that computer. Thank you.
California is unique among every other United States jurisdiction in that it permits a fee, according to Peck versus Morgan, north of reasonable but south of unconscionable, if it's provided for in an enforceable contract. All of the other jurisdictions, the limits on what an attorney may charge, the default in all cases is a reasonable fee. So a conversion clause that results in a reasonable fee is no harm, no foul. The second problem I have with going to foreign jurisdictions is that, in addition to that difference, on being told that Fracassi isn't directly on point, and then the one case that we did find, the Scarpa case, which is on point, really couldn't be listened to or carry weight because it was in a disciplinary opinion, which it was just one of many of the attorney's defalcations. While on the other hand, we would seek to insert into a California COPRAC official ethics opinion out-of-state authorities which state some law which would be the way we would want it to be, not the way it is in California. And it's against that background that I read all the articles, I read all the cases in all the articles, and I think there's one exception in a Colorado case which didn't come to the same conclusion, which is that if it isn't reasonable, it's not enforceable, even in those jurisdictions. So, and secondly, and then additionally, if the Fracassi case is correct that without a conversion clause, the attorney is entitled to fire the client with or without cause, and that the attorney is entitled to recover the reasonable value of the services up to the time of discharge. I imagine this negotiation. Client says, attorney, tell me what are my rights? Can I fire you? Yes, you can. When? Anytime, with or without cause. Great. What's it going to cost me? Well, according to the Fracassi case, it'll cost you the reasonable value of my services up to the time you exercise your unfettered right to discharge me. Okay, then can I discharge you then, with or without cause, wait to see if the contingency happens, and you get your reasonable value? And the attorney says, no, In my case, you're going to have to pay something now. You have to pay something extra for exercising a right which the law gives you in my contract. I'm real uncomfortable with that negotiation because I've seen what it results in.
I do think it's a really interesting issue as to what extent you can contract to lessen or go around obligations to the client set out in the RPC. Because obviously you can't have a prospective waiver of your malpractice. You know, you can't do that, and it would never be valid. It'd probably be an ethical violation to even try to do that in your agreement, you know, things like that. So if you view this as burdening a client's right to determine the course of litigation or to fire their attorney with or without cause, I don't think liberty of contract necessarily says it's okay. But I admit this is it's not an area of great certainty.
I think we all agree on that. I think the disagreement is whether or not it always does that, whether it always offers.
Whether it would always be such a burden. Well, here's a a new thought. We seem to have unanimity that, and I might be wrong about this, but that conversion clause is triggered off of the decision to accept or reject settlements. That's just a no-go. I think everyone thinks that's a no-go. And if that is the case, that is our collective thought, is there benefit to a narrower opinion that says that right now while we hash this out for another 4 years as determination? So that's just a thought. Joel?
Yeah, Brandon, I think we've discussed this option that I've suggested.
We've discussed every option at some point.
No, and this is the option that I've suggested at this point regarding this impasse. Why don't we pass out for public comment the no exceptions rule opinion and see if there's members of the public who can do what we've been unable to do internally, come up with that golden solution of the case where it actually would be ethical to do it. Let's find out. So the only way we can do that is by opening it up to a wider group of scholars, and particularly the community who lives and breathes on contingency contracts, and see what they say.
And I would just note that we've done that in other areas where we've had people on the committee, myself included, for example, with the expert witness opinion, will vote things out for public comment, which doesn't necessarily mean we support it. I just want to hear the comment. It doesn't mean I would vote for it in final form. That's one way to go. I would suggest, Joel, that I think the draft, if that were the approach, needs to be tweaked further to be a clean, ready for publication, or public comment draft. If the committee wanted to do that, I think we would need to make some more drafting changes to have a draft that reflects your, absolutist position go out. But I like this idea, and maybe we'll, you can make a motion in a moment. But I want to hear from Sarah real quick.
I just wanted to point out that the initial round of public comments on the draft, it included public comments from individuals, and I think also one organization. It's been a little while, but that did come up with hypotheticals that they thought would be permissible. And we discussed that at prior meetings too. And I do agree that some of the hypos presented through the public comments would be permissible. They weren't fleshed out entirely, but that has been addressed to some extent in the initial public comment round.
Okay. So do we want to push on, or do we want to take a lunch meeting? A lunch break, a lunch meeting. Do we want to take a break for lunch, or do we want to just see where we go with this and maybe wrap really early for the day? Who wants lunch? Raise your hands. All right, we're going to keep talking, and we're going to use our hunger to motivate results. It's going to be exciting.
May I just make a recommendation? I think it might be useful to kind of do like a straw poll on some of this stuff, just because, you know, I know the working group has, you know, is we're divided, right, essentially. And so it might be helpful to see of the group, like who is in favor of you know, conversion clauses are not permissible in any situation, versus they might be permissible in certain situations. Like have a straw poll on both proposals, because that might inform, because it seems like if the majority of us feel that the conversion clauses, let's say, are not permissible, then I think Joel's approach does make a lot of sense, right? Even if there's some division, if, you know, let's hear from the public. I do think that makes sense. And I also liked your idea about, yeah, so I just thought it might be helpful to get, but I don't think I have a sense yet for where everyone's at. I know some people have expressed their opinions, but.
Let's just do a really informal thing, not a real vote, as to, all right, who's in favor presently, this isn't like a final binding thing, but who's in favor of the absolutist approach against conversion clauses that would ever give you more than quantum merit? And we'll just do hands, digital, or human. Who's against conversion clauses? Who's agreeing with Joel, generally speaking? I can't count. I can't even tell what I'm looking at.
Can you actually, if you can, virtually raise your hand?
Okay, and then we would go with who likes the more flexible approach with some daylight in here. 1, 2, 3, 4. Topeka, you had your hand up, right? Okay.
And then
Sorry, it was behind my name.
Vikita, did you vote?
I did. I agree with Joel.
Okay.
Okay. Well, this is a squeaker.
6 to 5.
Yeah, clear mandate, overwhelming mandate. Now, COPRAC used to really strive for unanimity, and I was thinking we could probably go with a little bit of dissension, but this is pretty tight. Interesting. Do we want to make a motion on these grounds, or do we want to continue chatting? Eleanor, do you have your hand up for a comment, or are you still voting? Okay.
Still voting.
All right. Well, we'll cut you twice then.
So I realized, Sarah, before we voted, and even before that, Sarah, you made a comment about before when we had the public comments, people, I think it was in reference to what Joel said. So whatever you said, I realized I wasn't sure. So therefore, are you suggesting we not send Joel's out? Because
No, I was just pointing out that there are some hypotheticals that have been proposed through the public comment period where they, you know,
okay.
members of the public express situations where they believe a conversion clause would be permissible. So I just don't, it's not the fact that there have never been any proposals of a hypothetical that might be permissible. The public comments did, you know, address that to an extent. They didn't go into great detail, but some of the public comments did address that.
Okay.
Sarah, there was
The
a
other
considerable
option
amount of
would-
attention given to those, that round of public comment, which resulted in a unanimous feeling among the three drafters of the current version. But, so it's not, some of that has been considered. That's all.
Yeah. Yeah, there was one anonymous comment that was extraordinarily involved and thought-provoking, and I didn't find it entirely persuasive, but I thought it was actually one of the most effective comments, and it was interesting that it wasn't a committee or a person putting his or her name on it. It was just an anonymous commenter. Raquel, you had something to say?
Thinking since we put out the one that we have, and let me just say, I was saying, oh, well, what if we did the one that is more, has some leeway for when it could happen, but I realize we don't have anything drafted.
Well,
That could go out in that way, and then we could,
actually, the history is a little different.
okay,
The one that we had public comments on had daylight in it. It said this is generally unlikely to be ethically permissible, but it could be. And we got lots of comments on that. So if we wanted to test new reactions, it would probably make a lot of sense to do something more along the lines of what Joel is suggesting. But I do think if we go down that road, we should probably work on the draft further, because I think there's a lot of vestiges that, are like testing and probing, but not as absolute as the ultimate conclusion. So I think the draft isn't ready to go out. The concept is ready to be straw voted on. I'm a little uncomfortable with a 6-5 vote, because I don't think we've ever been that divided. Eric?
I think it's not the same vote necessarily.
Right.
I think Sarah is in favor of a conversion clauses opinion that has wiggle room, but from what I heard, and Sarah, you can correct me if I'm wrong, you're not opposed to sending out a version of the opinion for public comment that says there's no wiggle room to get the benefit of public comment. Is that correct?
Yeah, I haven't really thought about that as such. I mean, I do think it might be worth, getting the benefit of public comment on that issue. And I think I've mentioned that even before, so it's not entirely wrong. I mean, that's not my preference, but I'm not totally opposed to that, I guess.
One note, I think we'd see a lot of public comment that suggests that there are a lot of fee agreements out there that have conversion clauses in it, and we don't have the authority to affect that.
Right.
There also was
Yeah.
a considerable amount of public comment which said we didn't go far enough with the wiggle room version, that we should have gone for
And I'll just
considerable amount, including from I think it was Orange County or LA Bar Association. I think it was the LA County Bar Association said, "What are you doing? You can't put this out unless you make it real tight."
And I'll just say, I mean, COPRAC opinions are always advisory and non-binding until a court adopts them. So even if people are saying COPRAC has no authority to do this, it's an advisory opinion. So it's just giving advice.
Yeah. Just
So
a preview of the storm that's coming.
Sure.
Yeah, it's coming.
Yeah.
But going back to Brandon's point, your 6-5 vote may not be the same vote as to just issuing the opinion for public comment.
Right. It's just to get it out, to seek comment
To get
is
more,
different
to get
than
more
saying,
input.
Yeah, different than saying, this is the opinion I want to be adopted.
Brendan, I think it would be interesting to know the basis of the folks in favor of a total bar. Like, how many folks think it's in the black letter law, it's binding, and how many think it's because, how many taking the position because they think it's going to operate, to interfere with the client's rights to change counsel or to make decisions and direct the litigation. I think that would be helpful to know.
Interesting. So let's just do another straw vote. Who thinks it's black letter law already and we're restating law? Raise your hands now. And then the next thing would be that we think as a matter of policy, it's required because it burdens these client rights. So we have 2 that think it's black letter law. And then who would do it as a matter of public policy? It would be me. And Elizabeth.
Well, I would also do it as public policy. I think both are true.
Right. Yeah. Elizabeth stepped out for a second, so we're losing a portion of our committee at the moment.
So mine is more on principle. I mean, there is a policy element, but I think it is the risk that you take as a contingency fee attorney. And it's built into, that's what it is, right? I mean, so to me, it's not, I don't know about the law, but as someone who.
Yeah.
If you take that kind of contract, you assume that risk.
Right.
And there's reasons why you do it, and there is also the public policy side as to, so I think that is, but mine is in some ways just, if you step back and say, how do you get yourself into this situation? It is a principle.
Yeah.
And so I think once you start finding areas of light, I think you're moving away from the principal element. overall, without whatever the legal and the contracts and all of that is,
Sarah?
so.
Yeah, I just had a quick question, because I understand Joel's opinion, because he drafted the kind of extensive memo and it has expressed, his view of Fracassi and SCAPA. I'm just curious, Dan, since you raised your hand that you think it's black letter law, are you relying on those authorities, Fracassi and SCAPA, or are there other authorities that you think are relevant here?
No, I'm thinking of those, but and in my mindset, I'm thinking of, would I advise a client to argue for the enforceability of a conversion clause in light of that authority? And I would say no.
Okay, thanks. That's helpful. I just want to understand.
There's also a few other authorities that I mentioned in my report that I could give support to that provision of it being maybe an unadvisable.
Cassidy?
Well, I know this isn't black letter law, and I know that I always refer to the purple book, but I don't know if you guys have looked at the fact that Fracassi, the purple book actually kind of distinguishes Fracassi and says that, a provision in attorney, that the attorney shall receive the full contingency fee if discharged prior to obtaining recovery is enforceable. So that provision is enforceable. It cites Fracassi, but then in a practice pointer, it says, your fee agreement may, however, provide the basis for determining the reasonable value of your services in the event you are discharged. For example, the agreement may provide that you will be compensated at an agreed hourly rate for services actually rendered. So it basically says you can have a conversion clause, the way we're describing it with the outline. And there's no citation after that. So this is not black letter law, obviously, but my concern is more practical, that I see these all the time too. And just it's just going to create a flurry of lawyers who have read this book, who use the conversion clauses and now or use this type of language. And now we're going to come out and say it's completely prohibited. It's black letter law. That's what Fracassi says. And I think that's just going to be a storm in response. So I have some of the same concerns, but I do think that language that has the controls on it that Sarah and Eleanor have come up with is consistent with what this says, and I agree with what that you can have that in your fee agreement.
Well, but
You
what you
can.
described is not a
Cassidy,
conversion
hold on a
clause.
second, Joel. One second.
It's an
Cassidy, you're saying-
agreement which
One second, Joel.
provides that if we get to
Joel?
the reasonable value calculation after the happening of the contingency, you agree that a reasonable hourly rate for me to be charging in that calculation is $500 an hour.
Joel? Okay, so Cassidy, I was just trying to hear, it wasn't 100% clear what you were saying whether they can or can't be a conversion clause in your fee agreement. What your point of view after considering the purple book and the
The purple.
you spoke very quickly. The microphone wasn't catching for me.
Oh, I'm sorry. Yeah, I think that you can have a conversion clause as long as it's consistent with the quantum merit recovery that you would ordinarily be entitled to. Well,
Joel's draft says a conversion clause is impermissible if it would give you more than quantum merit. Well, nobody's got a problem with quantum merit. I think. I'm wrong about most things I say, so I want to be careful with that. But the only question is if you have a conversion clause that would give you more than quantum merit. So, Sarah?
Oh, I was just pointing out the practice pointer that Cassidy was reading too, that's somewhat consistent too with what the LA County Bar Association said in their public comments in terms of, well, why can't, you at least agree up front that in the event of discharge or withdrawal for cause, I forget the exact language, that, to an hourly rate that will be paid for purposes of obtaining recovery. So you don't have to necessarily always go to the court to obtain quantum merit recovery. Even if you're saying you're limited to it, why not agree up front to the hourly rate? And I do agree that would be a permissible type situation, clearly. I don't think it's the only one, but just wanted to point that out.
Yeah, I mean, because I think that that's the providing, you know, more of a sense of certainty for the client, you know, I think that's kind of in line with that policy consideration, that's in favor of conversion clauses. It kind of, you know, manages the expectations of both the lawyer and the client without it being, you know, imbalanced.
So Elizabeth had her hand up in
It's-
human terms here, so I missed it. So I'm gonna call on
My
Elizabeth.
human hand is invisible. Does the practice pointer that you're referring to distinguish between the different types of termination of the relationship, like withdrawal or discharge, or withdrawal with good cause or without good cause, or does it just generically say that?
So this is under, that was discussed in another section of the book, but this is under prohibited provisions in engagement letters. So the prohibited provision that they're talking about is provision for full contingency fee in the event of discharge. So you can't say, you know, you can fire me, but I still get my 33 1/3%. That's prohibited, but then the practice pointer says, but you can say this. So it doesn't go into all of, you know, the reasons for withdrawal.
It's
And I
really-
haven't looked at whether or not it talks about it the other areas.
The hourly rate computation could be much larger than the contingent fee. And it's just not being, I understand that the practice pointer is suggesting something, but it's not digging in deeply into all the things that are bedeviling us here. Yeah.
Fair enough, but
No,
what I'm
yeah.
saying is that
I know you didn't write it.
there's a lot of lawyers who read this and say, oh, good, I'm gonna put this into my agreement, so.
Cassidy, let me share with you a real world practical example in a case I just got a phone call about a couple of days ago, where they had that, and they stipulated that if we go to a Cazares split when there's a subsequent attorney, then you agree my reasonable rate, I think it was $500. And now they're there, and the contingency has happened, and they're trying to split up about a $5 million fee. And the other attorney is claiming, well, my rate, reasonable rate, is $900 an hour. And so the attorney who stipulated the $500 an hour wants to get out of that and say, well, no, Cazares trumps all that because it says reasonable value, and that is based on factors not having to do necessarily with the lodestar, but in terms of the degree of the contingent risk based on primacy or subsequent conduct. The first attorney takes the greater risk, the second attorney doesn't. The first attorney develops the case, the second attorney may take advantage of that, and that differential rate should be thrown out. So that argument is being advanced in this case. Not by me, by the way. But anyway, that's what you get into when you go there. So I agree that perhaps it's worth a footnote to say that a good practice pointer is that you might want to include what your reasonable hourly rate is in the event you get into the Cazares fee split situation, or words to that effect. But be careful what you wish for.
It may or may not be binding or helpful. Dan?
Another way to think of it, and just going back to Brandon's comment that I think would mostly all agree, or we all would agree, that the settlement trigger would be impermissible, is what is really different about this? It might be the case that the client is better off if they take that settlement that's recommended rather than go to trial, right? So it could benefit the client at some point. But what we don't like about it is that it's impinging on the sacred right and unfettered right to choose how you dispose of your case.
I'm not, but by the way, I'm not so sure I'm on board with that. It's so I just want to note that I know there was general agreement on it, but for the same reason, I don't think it's always interfering with the right to settle. I'm not sure it's always going to interfere. I think you can negotiate that with a sophisticated client up front.
Yeah, that's what I was trying to think through, because
you're gonna pay me my fees because it's a lot more work and it's a lot more resources and it's a lot more risk, and I'm not willing to take that, but I'll take the risk up to the point of trial. To me, that's perfectly reasonable.
Okay, Eleanor gets the consistency award. For anybody else who thinks they're different, what is the difference if there is one? But that's good to know.
Interesting. All right, look, some of us have to eat food at some point, and nobody wants to come back after lunch. What do we do here? Do we just have I'm not going to make the full working group work on Joel's draft because half the working group doesn't want to, and that's fine, and I respect it. But I think we need to get a draft together for inclusion at the next meeting, so that there's something actually votable for public comment that isn't just a concept, but that we have actually made sure that all the body of the draft aligns with the proposed conclusion. And then we would, at the next meeting, consider a vote for public comment. Does that seem reasonable to everyone? And again, it's just to get the public comment. The only other approach I can think of is there's a lot of support for the idea that with regard to a settlement trigger, I think we could get, I think that could advance through this committee pretty easily, whereas the termination trigger is more fraught and complicated. Do we want to split this into two opinions? Does anyone, let's do a show of hands, does anyone think we should split this into two opinions, a termination of the attorney-client relationship opinion and a settlement opinion? Not a lot of enthusiasm for that. So I'm thinking we should take the next interim between now and the next meeting to turn Joel's suggestion into an actual draft that can be voted out up or down for public comment at the next meeting. Does anyone want to be heard on that? Or have we talked through sufficiently? I want everyone to feel that they've been heard even if they've been disagreed with.
Can I ask a question? When we say refusal to settle, like we're saying settlement trigger, so we're characterizing it as a refusal to settle.
Yeah.
But do people have the same feeling if it's just that the case proceeds to trial?
Yeah, I do.
Because that's not a refusal to settle necessarily, it's an inability to settle, right?
Most contingency agreements that I see are staggered, the first X number of months or before trial, it's this percentage. If we go all the way to pretrial motions, it's this percentage, so that's usually accounted for. And I have no problem with that, but I do think anything that where the attorney is trying to dictate the outcome such that we are increasing the risk or pressure on the client beyond the normal economics of a case. I'm telling you to take this settlement offer, and if you don't, and you wipe out at trial, you owe me as if that settlement offer came in. I think that's completely unacceptable. Or I think you've got a $10 million case, client. You should roll the dice at trial, and the client says, no, I'm taking to handle the stress. I don't think a client should have to pay extra fees for that either. And I know that's a horrible situation for a contingent attorney who believes in the case, but I think it's the client's decision. So yeah, that's what I meant. That's what I meant about the settlement trigger.
All right, Brandon, I will, if that's the way we go, I will leave everybody on the committee on my trusted receipt list on my email for a week or two. Then I'm going to go to work on it, especially you. I'd like to hear from.
Yeah, and we're going to include the
and see what we come up with. But I just think it's time we get this out. Public comment.
Joel and I want one vote to get it out for public comment before Joel and I no longer have a right to vote on things.
We were trying to wait until you leave the committee and then the issue's moot. So that's what we'll wait.
Exactly. Erica, is it okay to add Topeka to our working group, or are we getting too close to the numbers of anything?
So it's a new working group at this point.
Group. Okay.
So it would just be the three of you.
Okay.
I'm just trying to make sure I understand. So it'd be the three of you meeting, working on this until the next meeting.
Perfect.
That's fine.
Okay. Nobody's got their hand raised. This is thrilling.
Topeka, you must get these guys straight. That's what's been the issue with this group.
She's going to fix it. All right, listen,
Has not had a woman.
I want to thank everybody for robust, lively discussion. And I want to wish everyone a wonderful weekend, and I want to adjourn unless someone has something to say. Thank you. Have a great
Thank
weekend.
you.
All
Bye-bye.
right.
Bye.
Amazing.